If the voters of Denton, Texas pass a ban on fracking on November 4th, the ban will almost certainly be overturned by the courts, but only after months and perhaps years of expensive litigation paid for by the taxpayers of Denton. Now, why am I so certain that the ban will be overturned? Well, I'm not the only one. Former Chief Justice of the Texas Supreme Court, Tom Phillips, told the Denton City Council that the ban is certain to be overturned. And the City Council knows this as well. That's why they voted against the ban when it was put before them. Now, why will the ban be overturned? For two major reasons. First, the ban faces a jurisdictional crisis under Texas law. A city may regulate only certain local aspects of oil and gas activity, but it cannot regulate techniques, and it certainly cannot ban it altogether, because the Texas Railroad Commission regulates oil and gas activity at the state level. The Railroad Commission may have an antiquated name, but its authority is undisputed. And Denton can expect to be sued by the state of Texas itself for usurping the regulatory authority of the Railroad Commission. Again, the city of Denton can regulate certain aspects of oil and gas activity, as it has through its updated ordinance. But it cannot ban the activity without running afoul of state authority. Second, and perhaps most importantly, the ban violates the United States Constitution. Yes, really, the U.S. Constitution. You see, one of the tremendous virtues of the United States is that our system takes property rights very seriously. So our Constitution prohibits governments from taking private property without just compensation. The Fifth Amendment to our Constitution contains a takings clause that prohibits government from taking property without compensation. That's why when government authorities exercise eminent domain and take a piece of property for a road or for other use, it has to pay a just price for the property. Government can't just seize property and deprive the owner of his or her property. So, if the city of Denton says that mineral rights owners in the city cannot have use of their mineral rights, unless the city compensates them for this action, it's a taking under the U.S. Constitution. And there's firm legal precedent for seeing such bans as takings. In Michigan, a drilling company was awarded over $120 million, paid for by Michigan taxpayers, because the state of Michigan banned drilling in a particular area, just as Denton is considering doing. Now, those who are in favor of the ban casually wave aside this property rights argument. They say that a city can say that a bakery can't be built on a particular lot, for instance, which is true. But it's an invalid comparison. You see, that lot can have other valuable uses other than for a bakery. You can put a different kind of business, for example, on that lot. So you've not deprived the property rights owner of the use of his property. But a mineral rights only value is the minerals. So if you don't allow oil and gas to be drilled, you are depriving the owner of the entire value of the property right. It's clearly a takings without compensation. Property rights is one of the reasons the United States, and Texas for that matter, have had such consistent freedom and economic growth. Without property rights, you can't have contracts because you don't know who owns something. And without contracts, you can't have markets. Property rights are foundational to a free market economic system. So no one should treat them so dismissively as do the proponents of the Denton drilling ban. If voters in Denton pass the ban on drilling, they will not only be dismissing the importance of property rights, but they will also be putting themselves on the hook for enormous legal fees to defend an illegal ban that will almost certainly be overturned. It's a futile and expensive mistake. Think about that when you vote on November 4th.